Hello, and welcome to this lecture on police interviews with suspects from a police perspective. My name is Dr. Andy Griffiths, and before becoming an academic, I was a UK police officer and detective for 30 years. From very early in my service, lawyers were admitted to police interviews with suspects as a result of a change in the law. So for most of my career, I've been used to this situation, and I've worked with lawyers present in interviews, in all sorts of interviews, from theft to murder. So I'm going to be talking to you on that subject for the next half an hour, and I'm going to cover three relevant areas, I think, to this subject in order to help you with your role. The first one of these is whether it is, in actual fact, an interview or an interrogation. This is a fundamental question in relation to the subject, and one I'm going to spend the first few minutes dealing with, so that we're absolutely clear about what it is you should be partaking in when you're representing a client. The second thing I'm going to talk about is the police objectives in an interview. If we accept that we are talking about an interview and not an interrogation, then the police have a clear role to play, and there should be some things that you should be able to observe about their behaviour and the way in which they conduct both the interview and the investigation that will be relevant to your role. So we're going to spend some time talking about the police objectives in an interview, what a skilled interview looks like, and conversely what a lack of skill also looks like, which are all relevant to your role. And the third part of this lecture is about your role in working with the police. It's very easy for this to be seen as a confrontational or adversarial position, and even for that to extend to arguments and a breakdown of any formal working relationship between the police officers and the lawyer and indeed the suspect. So I'm going to talk to you about that and about how that working relationship needs to be productive, and some ideas about how that can operate, both from my own experience and from research. So, interview or interrogation. It's fair to say that interrogation has been both an important and controversial part of criminal justice in the eyes of everyone involved in it for many, many years. The first mention of interrogation and its problems goes back to the start of the 20th century. But coming more up to date, academics all over the world have recognised that police interrogation does play a vital part in justice, but also it is the most controversial feature of the whole process. And I'll go on to talk in a minute about why that is. So that quote there comes from a UK academic in 1980, at just about the time when laws were going to be changed in the UK. Coming much more up to date, and in another country completely, Richard Leo in his book said this, or quoted this, much more recently. And of course, the American system has a rising number of miscarriages caused by interrogation. And indeed, that brings me to the next point, that really, across the world, interrogation really meant seeking a confession. And that has been true globally. And the first place that really changed was in the UK in 1984, with the law changes that I've been referring to. So let's talk a little bit about those. During the 1970s, there was a rising tide of dissatisfaction with the way in which the police were obtaining confessions in interviews. A number of major cases, including terrorist bombings, produced disputed confessions, and this was raised by lawmakers repeatedly. The case I'd like to refer to goes back to 1972, and it wasn't a huge case in terms of terrorism or a significant victim. This was the case of Maxwell Confey. Maxwell Confey was the victim of a murder, and a young man, 17-year-old man, was coerced into admitting that crime by bullying police interrogation. Right from his conviction, There was disquiet about the confession he produced. There were 2 other people also convicted. And over a number of years and a number of inquiries, he was eventually exonerated of that crime. And I think this was one of the first cases really where interrogation and confession came firmly into the spotlight, and there was widespread dissatisfaction with the manner in which he was interrogated and the result of that interrogation. And as I said, this led to the 1984 significant changes to the law in England and Wales, which amongst other things allowed solicitors into every interview, free of charge. The government provided it to show the size, how much things were going to change. And what that revealed was a number of things, including a severe lack of skill amongst police officers conducting these interrogations, and the way in which they were still focused on guilt and made premature assumptions about the guilt of people they interviewed, somewhat contrary to what they should have been doing. It took a few years, but by the early 1990s, the science on this was much better understood, and people such as Gisliger Johnson produced whole books on the effect of coercion in producing false confessions to crimes that were committed. So much so that whereas in previous cases that I spoke about, the defendants were convicted but then cleared on appeal, by the early 1990s, judges such as the one in the picture here were saying things like this about interrogations that were put before them, where they recognised this bullying behaviour. These comments here were made in relation to, again, a man with learning difficulties interviewed about the murder of a 6-year-old girl. And the judge was so critical of the interview that the case did not even get before a jury, and the case was thrown out because of the bullying behaviour of the police officers and despite the confession it produced from the suspect. So, if we are going to agree that interrogation is about confession and that produces issues for the criminal justice system, there needs to be an alternative. And so this is what the alternative is. And this I take not from a British piece of legislation, but from a European report by the European Committee for the Prevention of Inhumane and Degrading Treatment, their 2001 report. And this provides a very useful modern-day definition of what an interview should be about. So let's look at this in a little bit more detail. Firstly, it underlines what it's not. It's not to obtain a confession from someone already presumed in the eyes of the interviewing officers to be guilty. Very, very clear. But it is about obtaining accurate and reliable information in order to discover the truth about matters under investigation. It's a very, very useful definition. That tells you that at the start of the interview, the police officers must not have made up their minds about what has happened and just be seeking confirmation or agreement from their suspect. There should be a genuine commitment to asking questions and discovering the suspect's version of events. Now, of course, suspects in most countries have the right to silence, and they don't have to give that version. But that is what the interview is about. It's not about spending time convincing the suspect that the police's version of facts just needs to be accepted, and just with some reasons as to why they've committed the offence. So that's a very, very useful definition, and one that I think, rather than being drawn from British law or any other country's law, is general and is a good one for you to remember when going into these situations. So, if that is the definition of an interview, what is the role of the police? Well, in an interview, the police's role is to obtain the suspect's account, not to tell them what they think has happened, not necessarily to tell them what other witnesses have said so that they can agree with it. It is to obtain the suspect's account. It's also to establish the points to prove. Every offence will have points to prove. So, for example, if in a stabbing, one of the points to prove would be that the suspect did or did not push a knife into another person. So the question should be geared around establishing whether that is what happened or not. Similarly, every offence will have defences, lawful excuses why someone has not committed an offence. So in the example I've just given regarding the stabbing, a lawful defence to that could be self-defence or an accident. So again, the police officers should be asking as many questions about that possibility as the possibility of them committing the offence, particularly if a suspect at the start of an interview says, look, yes, I was there, but the man came at me with a knife and I had to defend myself and I turned the knife back on him. Now, it's not for police officers to dismiss that explanation based on other witnesses maybe saying something different. It is for them to ask questions and examine that and to see if it is accurate and reliable. If, for example, they are in possession of evidence from another witness that says the suspect went to the location already armed with a knife, then obviously the police officer would know that maybe this is a lie, but it's certainly not for him to say that at that point. And it's also to put the main evidence to the suspect. So, having examined that account in the example in which I've just given, I would expect the police officer at some point in a good interview to be saying to the suspect, now we've listened to what you've had to say, you've explained about how this was self-defence, I now need to tell you about a witness who saw you go to the location armed with a knife, and then to ask questions about that, maybe about their particular sighting, maybe about their relationship with that witness, any reason why that witness would make something up, but certainly it's putting that main evidence to the suspect. That is good investigation work. Just a little point on the dynamics of this. Of course, not every case is the same, and it's not the case that the police officers gather all their evidence and then bring someone in for questioning. Depending on the dynamics of the crime, you can have an early arrest immediately after an incident has taken place when the police have very little other evidence, to a planned arrest. And certainly for yourselves in the role as lawyer advising a client, it's of great relevance to you to know when the offence took place in relation to when the interview is. If it's been a period of months before your client is interviewed, I would suggest there must be a pretty good reason why your client has been interviewed at that point. Similarly, if your client is within minutes of an offence, maybe still got some blood on them from a fight in a bar or something like that, then it's likely that the police will either want some time to interview witnesses or will only have the barest of accounts from people who were present at the scene if your client was arrested at the scene. Suspects can also be arrested on more than one occasion in an inquiry, and again, particularly I would suggest if it's some time since your client was first interviewed, he's going to be interviewed again, there must be some more evidence, and the police will not just be able to bring the client in for another go because they did get an admission the first time. So these are all factors to look at. And similarly, multiple suspects. It's very easy to think about this subject in terms of one victim, one crime, one suspect, but life isn't like that. So again, another dynamic is where there are multiple suspects. You need to know where your suspect is interviewed compared to other suspects. Are you representing them all? These are all real life issues that change the theory of the subject, shall we say. So let's now look at the skills required by the police officers. It's a complex thing to conduct an interview, and as I said, when lawyers were admitted to interviews in England and Wales, and when those interviews started to be recorded, which is also through legislation, the lack of skill came out of those interviews loud and clear from research that was done, and so a training program was put in place. There's been training programs all over the world in that time, and the science of interviewing is understood much, much better. But these are some pretty general skills that police officers need. 1, rapport. What is rapport? Well, rapport is that working relationship. It's that ability to communicate. So again, both with you and a suspect, police officers should be polite. They should be empathetic. They should be talking in a plain way about the offence they're investigating, what it is they need to do, and they also should be open. Now, I don't mean open in terms of telling you all the evidence. I mean in terms of saying, you know, okay, we're going to be interviewing for a couple of hours now, or your client might be here for a couple of days whilst we investigate this, that type of thing. All of those things are known to build the working relationship and to facilitate communication. So police officers need rapport. Aggressive, antagonistic, confrontational police officers do not generally get people to talk to them. They also can cover up a lack of confidence and a lack of skill. Secondly, listening skills. If an interview is not about telling a suspect what they've done and getting them to agree, but is about obtaining their account, then listening skills are vital. Lots of people talk about listening skills but don't really understand what they are. Listening requires intense concentration. That is to banish from your mind other considerations at the time and focus completely on what a suspect is saying. So if you see a police officer fiddling with papers in the file, looking at their mobile phone or something, they are not concentrating. A genuine commitment to listen requires that commitment to concentrate. It also means not interrupting. So once the suspect is asked to give their version, the police officer should listen and just aim to prompt the suspect to carry on until they've covered all the relevant information. Now obviously some suspects won't want to talk and will need to be asked more detailed questions, but certainly they should never be interrupted unless they're being completely disruptive themselves, and that's rare in my experience. Police officers should also share the talking time. This is not about long monologues where the police officer tell the suspect why they've committed the offence or why they should admit it. This is about asking them for about their whereabouts, their actions, their reasons for doing something, their reasons for possessing certain things, all these things, and that means sharing the talking time. In the ideal interview, the suspect will do far more talking, almost like a witness. Police officer also needs to check their understanding, otherwise known as summarising. The police officer, having asked questions on a topic, should then summarise the main points of what's been said back to them to ensure they've understood it correctly. Again, this shows the suspect that they're listening, and this consolidates what's been said in their own mind. Now, of course, if it's lies, then of course they will be checking it against other stuff they've got in their head based about the case, but that should still be the same, where they will check that understanding, say, have I got this right? Are you saying to me you never went to the bar on that night, you were actually somewhere else and these people can vouch for you being there? That type of thing. And similarly, in terms of that summarising, they will not word pick. So even if a suspect has said something like, yes, I did stab him, but it was in self-defence, they won't be jumping into, aha, so you did stab him then, as some sort of guilt confirmation. So listening skills, very important. Going with that, questioning skills. Again, police officers can be tempted to talk in very, very sort of technical language, but a good questioner will ask simple questions, single questions. Can you tell me where you were from 6 p.m. to 9 p.m. last evening? Can you tell me about the car you own? Can you tell me about the conversation you had with the victim? Those questions should all be relevant. If a police officer suddenly starts asking about your client's temper, or when was the last time they lost their temper, there should be a clear reason for that. And that doesn't automatically, temper does not automatically produce guilt of an individual assault. So you need to be on the lookout for that, and do not be afraid to challenge police officers asking irrelevant questions. Questions should be fair and appropriate. So in a sexual offences case, it is completely fair and appropriate for the police officer to ask questions about genitalia, sexual acts, if they're relevant to the offence. And indeed, a confident police officer knows they have to do this and can handle that situation sensitively but professionally. Organisation skills, what are they? Well, an interview should be structured. It's not like you see on the TV where the police officers ask 2 questions about one subject and then jump somewhere else in an effort to catch out the suspect in their response. This should be a structured interview where each subject is exhausted in turn. Those subjects are relevant and explained as to why they want to know about them, and summarised, as I said, in terms of the listening skills, and also they introduce evidence appropriately. Not always in your client's favour, of course, but they introduce evidence appropriately. That's not an ambush, that is making sure that They're not just handing the suspect and all the information to weave a lying account round, or even leading a suspect by telling them about certain evidence. Organisation skills, very important. And the last thing is an investigative mindset that sits over all of this. What is an investigative mindset? Well, it's this. It is a police officer who is objective, inquiring, probing, fair and balanced. So if your client says this was self-defence, they will ask as many questions about the self-defence explanation. Or if your client says they weren't at a particular location, they will ask questions about where they were and probe into that, and not just say, no, that's not right because I have a witness who says you were there. So that's the investigative mindset. Looking at a crime from both sides, not just coming in with the victim's account and thinking that your client has done this, so we just need to work out why it happened. So that investigative mindset sits above those other communication skills and is very, very important. There is a series of tools, if you like, a series of skills that the competent interviewer requires. And of course, not all police officers have these. And in many countries now, interviewing is seen as a specialism where people receive appropriate training, and only certain officers will be allowed to conduct interviews, particularly for very serious crimes. So what does good look like? Well, good looks like a well-prepared interview. You should be able to see that. Good looks like a structured interview with these subjects that are exhausted one by one, where you're not seeing another officer jumping in and asking a couple of questions about something that you last spoke about 20 minutes ago. It's an interview where the suspect is allowed to speak without interruption. That is good. It's an interview where they're asked non-leading, plain, relevant questions. It's an interview that avoids personal opinions. Well, I think this is what happened. It doesn't matter what the police officer thinks. It's what the evidence suggests that is the important thing. Good also looks like you getting the odd surprise about evidence that's produced. You can't expect to know all the evidence before the interview starts. Tactically, you can see how naive that would be. So a good police officer will introduce evidence fairly and appropriately, and I say not always in favour of your client, but that is what good looks like. They've thought about this. And again, good looks like probing and checking the suspect's account. That might mean, some fairly rigorous questioning, but as long as it's fair and balanced and not leading, that is a good interview. And lastly, a good interview will query inconsistency in your client's account, and that can also be uncomfortable. But just because there are inconsistencies still doesn't mean that your client is going to get charged. Some situations are very, very confused. So that's what good looks like. So lastly, the last part of this, lawyers working with the police. Well, first it's important to say that, of course, your primary responsibility is to your client, and everything you do is geared towards that. And again, a skillful police officer knows that, and they should not be aggressive or confrontational when you do that. They should understand that position. Your role in this is vital in balancing the powers of the police and the rights of a suspect in custody. So your role isn't passive. You are quite entitled to find out why your client is there. And a skilled police officer should be ready for those questions and should understand. You're also there to investigate the police case, not just accept what they say. But in order to do this, I'm going to suggest that you need to build a relationship with the police, not adopt this side versus side approach. Build that working relationship, use empathy, use rapport. So really, lawyers need interview skills, in other words, to probe the case the police present to them, and negotiation skills to persuade them to tell you more in order that you can best advise your client. For this, I'll just suggest quite a useful mnemonic from a book that I co-authored with Professor Eric Shepherd that applies to any conversation really, and is the rules about how you get a good response in a conversation. Firstly, respect. Avoiding this confrontational, adversarial, antagonistic situation. Secondly, empathy. You both have a role to perform, you and the police. Understanding that means you can both get on with that. You won't always agree, You don't have to agree, but empathy means appreciating the other's position. You can, to an extent, support each other. You know, if the police have a role to do, they have to ask some questions in order to investigate further, then you can support that as long as the law allows it. Seeing the bigger picture. That type of support will produce reciprocal behaviour from the police officers. It's about being positive, open and non-judgmental. You know, despite maybe negative experiences with police officers before, you should treat every police officer as an individual and in an individual case, and start out with that positive attitude. And again, if the police officers are confrontational, you can point out the negative sides of that behaviour, but it's about starting on that positive sense. Again, straightforward talk. Lawyers, you have your own technical language, and again, that can make police officers feel quite intimidated, or if it's a young police officer, that, you know, quoting your experience or the amount of years you've been practicing can make them feel a little bit attacked verbally, should we say. So again, having that straightforward talk, working with them as another professional, both there to do a job,